What protective orders are there? What statutes control the issuance of protective orders? How are the processes of getting the protective orders different? How are the protective orders issued? Who can do that? Those are the topics that we're going to cover today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We are a family law firm located in Vienna, Virginia. I analyze challenges and I find affordable solutions for families and their family law needs. Now, as a matter of introduction here, protective orders narrowly, domestic violence broadly covers a broad variety of disciplines, whether it's political, social, legal, and so forth, and very broad in scope. And the consequences of the systemic violence and things like that have broad-ranging effects, not only on children who witness that, but also on the adults that may be subject to that. So today we're going to focus just on the 3 statutes that authorize a court to issue a protective order. We're not going to go into the protective orders for non-family members as defined by statute. We're not going to talk about the criminal charges that can also come about from the same things. So kind of a fact scenario to get us into this. The protective orders usually come about from, there are some incidents of domestic violence. For the emergency protective order, we'll talk about that the police come to the scene and they identify who the primary aggressor is. They place them under arrest, take them down to the police station for processing. While they're down there, the police officer will have a warrant for the criminal charge issued and also file a petition for the emergency protective order. If the police aren't involved, then the victim of abuse can go to court and try to start out with the preliminary protective order. So that's kind of our fact scenario here is, let's start from the proposition that there has been an incident of domestic violence. Now, common to all the protective orders are 2 terms that we have to define here. They're defined at Virginia Code 16.1228. The first one term is family abuse. Family abuse means any act involving violence, force, or threat that results in a bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury, and that is committed by a person against a person's family or household members. And then the definition continues, but it's the and against family or household members. There's the key phrase. Because the next term defined at that statute then is what is a family or household member. A family or household member means a person's spouse, whether or not he or she resides in the same home with that person, the person's former spouse, whether or not they reside in the same home, the person's parents, step-parents, children, stepchildren, brothers, sisters, half-brothers, half-sisters, grandparents, and grandchildren, regardless of whether they reside in the same home or not. So it's not the living together, it's the relationship that's key here. It can also be the person's mother-in-law, father-in-law, sons-in-law, daughters-in-law, brothers-in-law, sisters-in-law who reside in the same house with that person. So now we do have a co-location requirement. It can also be Part 5, any individual who has a child in common with the person, whether or not the person and that individual have been married or have resided together. And then Part 6 is any individual who cohabits with or within the previous 12 months cohabited with that person, and any children from either of them residing in the home. So pretty broad definition, but in order to go through with this, that would be the first thing that a court or that the opposing side is going to say is that the alleged victim does not fall within the definition of family member. So you have to have that family abuse, which kind of is more basically stated as either an act of harm or a reasonable apprehension of an act of harm that's pending against a family member. So then if you have that act, as I said, if the police come, then they take you down and they take the perpetrator down to the police station for processing. And that's when Virginia Code 16.1253.4 comes into play. And I'll put links in these down in the description for this video. In that emergency protective order, any judge of a circuit court, general district court, or juvenile domestic relations district court, or a magistrate may issue a written or oral ex parte emergency protective order pursuant to this section. So we covered earlier in our video on the court structure as to the courts that exist, the general district court, the juvenile domestic relations district court, and the circuit court. In this instance, you don't have a court necessarily associated with the magistrate, but that's the other person who's authorized to do this. The order can be either written or oral. So the respondent or the perpetrators there down at the magistrate's office with the police officer, they can issue that oral order, or most often it's a written order. The conditions necessary to issue that emergency protective order is that the law enforcement officer can get it. So this is one where the law enforcement officer can get it. The next two we'll talk about, it has to be the victim that petitions for it. But it can also be the allegedly abused person. They have to assert under oath to the judge or the magistrate as to the facts and evidence that support their petition for the emergency protective order. And then either the judge or the magistrate has to find one of two things. The first thing they can find is that a warrant for a violation of Virginia Code 18.257.2, that's the criminal assault on a family member, has been issued. That's the one that the police officer would do. And they find or fact there, or does have to also find that there would be probable cause of further acts of family abuse against a family or household member by the respondent. So that's the first condition that has to be made. Or part two is the judge or magistrate can also look and see if they can find reasonable grounds existing to believe that the respondent has committed an act of family abuse, or there's probable cause of further such offenses against a family or household member. So you may have an act of violence. It may not be sufficiently established to rise to a criminal charge, but enough to meet the civil standard that would apply here for a protective order. Because of the limited information that's available on this, it's also what's called an ex parte hearing. So an ex parte hearing is only one side gets to tell their side of the story. We'll contrast this later on with the permanent protective order hearing, where both sides have an opportunity to be heard. And so because only one side of the story is being presented, there are some limitations on what the scope of the order can do. So for the emergency protective order, the limitations are, there's basically four things that it can do. The first thing it can do is the order can prohibit acts of family abuse or criminal offenses that result in injury to a person or to property. The second thing it can do is prohibit contacts by the respondent with the allegedly abused person, as well as family members and so forth. It can grant the occupation of the premises or the household to the alleged victim, and it can also grant the petitioner for the emergency protective order possession of a companion animal. And so that's what we'll see in the course of the statutes here. Over the past few years, the statutes have been amended to provide for keeping a cell phone. For instance, we'll talk about that here later. You know, the cell phone number and the cell phone service has become so personal, and the victims were, being denied access to their, contact sources and so forth, that the cell phone was taken away. So then that was subject to the protective order. Likewise, if you can't harm the person, then you can harm the companion animal. So they were put in there with a protection as well. So, just kind of an interesting evolution as the matters are added to the protective orders, as society values and things like that change, and recognize the importance of these things over time. The key here for the emergency protective order is that it expires the third day following issuance at 11:59 p.m. So just before midnight on the third day, the emergency protective order expires. And when it expires, then there is no limitation on the respondent. They can go back and move back into the house, contact the family member, whatever they want to do. That 3-day limitation can be extended if on the third day the courts are closed. So if it was a federal holiday, then it would bump to another 24 hours and be at 11:59 p.m. on the next available day that the courts are open. So you could conceivably have a weather-related emergency where the courts may be closed for several days, and the protective order would continue until the courts are open and allow the petitioner to get in to try to get the preliminary protective order we'll talk about next. So a lot of these, from what I've seen in practice, is the 3-day order will be allowed to expire. It's kind of a cooling off period, and the victim won't go down and extend this for another to try to get the 2-week order we'll talk about next. So it'll expire. The family member moves back in together, and they resume going about life and try to behave themselves in the future. Then during that 3-day period, that's the opportunity for the victim to go down and get what is called a preliminary protective order. The preliminary protective order, again, is an ex parte order, so only one side's being heard, but in this instance is good for 2 weeks, or actually for 15 days. The order here comes from Virginia Code 16.1.253.1. And again, in this instance, it's to a court only. So a judge does issue this one. And the process is the petitioner or the victim goes down to court. They either have to try to contact the court for a hearing, or they may work with the intake officer. Different courts do it different ways. In some instances, they will, the intake officer will make the arrangements and escort the victim in to talk to the judge directly. In other instances, the intake officer will work with the victim to prepare an affidavit then for the judge to review. In years past, it seemed like the courts did more of the affidavit, and so the victim would have to write down a brief explanation or as to what happened and the basis for them seeking the protective order. For us, who represented the person responding to the protective order or the perpetrator, that would give us a paper record that we could then review to see what it is that would be happening at the trial, or what the basis was for the protective order against our then client. So then we come in, the judge makes a determination as to whether or not to issue this preliminary protective order for 15 days. Because there's a greater opportunity for hearing and more information can be presented, the scope of the order is a little bit broader. So again, the order can be issued prohibiting acts of family abuse, criminal offenses, similar to what we saw previously, prohibiting contacts with family members and so forth. We saw that earlier. Grant possession of premises occupied by the parties. That's kind of a carryover. And now a new one here that we've added with the preliminary protective order is it would enjoin the respondent from terminating any necessary utility services. So that was kind of always the retaliation is, if you want to subject me to a protective order, I'm going to go down, I'll shut off the electricity, the water, and so forth. So what this preliminary protective order would prohibit that from happening. It would also, this is, item number 5 is where the court can order the cell phone service or the cell phone number and the device be made available to the victim here. Item number 6 is it does provide that the court can award an automobile that the parties own to the victim, so they would have their transportation. In the event, for some reason, the victim has to be removed from the house or leaves the house, then this preliminary protective order can provide that the perpetrator have to provide alternative family housing. We do have the provision for the companion animal, as we saw previously. And now, as we see in a lot of these statutes, the last factor is any other relief necessary for the protection of the petitioner and the family and household of the petitioner. So So that goes on about it. As occurs by hearing. At the end of the hearing, the judge hears the petitioner's basis for their petition to get the preliminary protective order and decides whether to grant the preliminary protective order or not. Now, with the emergency protective order we just talked about, serving the respondent is relatively easy because they're all down there at the police station together, the police officers there serving the criminal warrant and serving the emergency protective order as well. Where we can sometimes have difficulty is with this preliminary protective order is how do you locate the respondent to serve them the order, because the order is not enforceable until it gets served on the respondent. The other thing that happens here too is when the order is entered, it gets entered into the Virginia Criminal Information Network. So there's some records sent out so police officers and law enforcement are able to check to see what the status is of the order and that the order exists. But in this instance, because it is ex parte and it does affect rights, and there's a whole separate matter on matters of possession of firearms that's apart from this statute that we'll talk about on another occasion. The respondent has to be provided an opportunity to tell their side of the story, that there's a contested hearing within 15 days of issuing this. By the statute, these hearings are to give priority on the court's calendar. So we have an earlier video on the judicial emergency. One of the hearings not subject to the judicial emergency that was required to go forward and have priority on the court's docket were these protective order hearings. As I said, the respondent has to be personally served. If they're not served because they're incarcerated or they weren't transported to the hearing, then the court may go ahead and extend the order. Likewise, if the petitioner can't locate the respondent within the 15 days provided, then it can also be extended for another period until you do locate the person and get them served. Part of serving the protective order also includes providing the respondent notice of when the hearing is that they have to come back so they can tell their side of the story. In that instance, when they come in for the hearing, if the respondent feels that they're not prepared to go forward that day, or they want to acquire more information, for instance, if they want to do a bill of particulars to learn more about the basis for the allegations, then the court can continue the hearing at the respondent's request, but the respondent gets that continuance on condition that they remain subject to the terms of the protective order. So that's kind of where we go through. So we've got the emergency protective order good for 3 days, the preliminary protective order good for 15 days, and then we come to what could be called the permanent protective order. It's not permanent in the sense that it's goes on in perpetuity. They can be limited to 2 years subject to renewal, but the idea is you kind of have a parallel, the emergency protective order, preliminary protective order, permanent protective order there. So the statutory authority for this one comes from 16.1, 279.1, and in cases of family abuse, the court can issue a protective order to protect the health and safety of the petitioner and household or family members, and then there are a list of what the order can cover. The first thing that the permanent protective order can cover is, same as with the previous two, prohibit acts of family abuse or criminal offense that results in injury to a person or property. So not only is the person protected, but you can't come, vandalize the automobiles, vandalize the outside of the house, things like that. Also prohibit contact by the respondent with the petitioner or family members as the court deems necessary to protect the health and safety of the petitioner or the household members. And what we kind of see here with the emergency and preliminary protective orders is more of a blanket, zero contact whatsoever. For the permanent protective order, because the parties will be subject to this for the long term, if they have children together, what the court will do instead of a blanket prohibition is say, contact by email only, contact by text message, contact by third party, something like that. So the victim and the perpetrator would be prohibited from being together, but they would be able to have communications, and it could also be that the communications be limited to matters affecting the children or something like that. Also keep in mind with regard to these protective orders, the perpetrator is subject to the order, but there is also kind of a corresponding obligation that the victim or the petitioner also has to stay away. So you can't go out and get a protective order against the person and then start trying to force them into violation by coming within so many feet of them or approaching them or things like that. So that's something we've seen in the past too, is the person says they're a victim and yet they turn around and keep chasing the perpetrator around and so forth. Factor 3 is they can grant possession of a residence. Again, keep the utility services, keep a cell phone number, keep a vehicle, alternate housing as before. Then the 8th basis of relief that the court can provide that is new for the permanent protective order is order a respondent to participate in treatment, counseling, or other program as the court deems appropriate. So usually this is one where you at least see the anger management order come out here, where the perpetrator has to go to anger management. They may have to take a parenting class or similar classes to that. As we saw previously, Factor 9 is the court can award a companion animal, and again, Factor 10 is the any other relief. As I said, the permanent protective order can be good for up to 2 years. It is subject to an extension, so what you would do is allowing sufficient time to get on the court's docket and to be heard before the 2 years expires, you would petition to have the order extended, and then it can be renewed for up to another 2-year period. Sometimes what the courts will do is there may be a incident of abuse, but the order will be limited to 1 year, which kind of corresponds with the period of separation required for a divorce. I think at this point it would also be worth saying is part of the things that judges look at here is this part of divorce planning? Is someone seeking a protective order because this is the way you get the other spouse out of the house so you can start your 1-year period of separation that's necessary then to secure a divorce? The protective order will be served on the respondent and the petitioner as soon as possible. Usually what happens at the end of the hearing, the judge and the bailiff tell the respondent to sit fast for a minute. The judge will complete the order, issue it. They'll make the copies. They'll give copies to everybody. The petitioner will be excused. They can take their copy and leave, and then the respondent stays back, first of all, to keep them away from the petitioner, and then second of all, the bailiff would fill out the certificate proving that the respondent had been served and has notice of the issuance of the protective order. Again, this goes into the Virginia Criminal Information Network. Also, with the permanent protective order, there is a provision here at paragraph E where a court may assess cost and attorney's fees against either party regardless of whether an order of protection has been issued as a result of a full hearing. So if someone is of limited financial means or indigent, there is the provision here where the court can move some of the cost of that around if you have to seek counsel representation for that. So that's kind of what we've covered here. The other matters, I'm not going to do these videos in a series, but we will have other episodes coming up later that will cover the criminal charge. We'll also do one, in this one we've talked about the petitioner and the victim's actions they can do. We'll do one later on and talk about the respondents or the perpetrator, what they have to do, and what with regard to getting counsel or making their appearances and going to the hearings and so forth. Also, we can kind of see how this ties into matters of divorce and support and so forth. The protective orders do provide that a court can address matters of support, temporary custody, and things like that. You can also look at Virginia Code 20-103. So we just, again, it kind of brings in the mesh or the network of laws here that all kind of interact and work with each other. And, in deciding what to do or what your course of action is, you can look at, you have a number of options and which would be the better, tactically and strategically, which ways to go for that. So for now, that's going to conclude our discussion on emergency protective orders, preliminary protective orders, and permanent protective orders.